Good afternoon, everyone. Welcome back to our third panel of the day, Antitrust and Big Tech, What's Next? Moderated by Professor Yoon, and our panelists are Jeff Manny, Bilal Syed, Matt Stoller, and Claire Z. I'll pass it off to you, Professor Yoon.
Thank you, Tim. And thanks for everyone for being here after lunch. Smaller group, but it's a separating mechanism. We are the true believers in here and we really love antitrust to be here. So thank you for joining us. Tim mentioned the panelists, but I'd like to sort of give a little more length, not a ton, but just to introduce everyone. So right here, I have Jeff Manny. He's president and founder of the International Center for Law and Economics. Prior to founding ICLE, he was a law professor at Lewis & Clark and also worked in Microsoft's legal department and in private practice. Next, we have Bilal Syed, who's senior competition counsel at Tech Freedom. Recently served as director of the Office of Policy Planning at the FTC. Bilal has spent literally decades in both private and public practice. Matt Stoller is the director of research at the American Economic Liberties Project, visiting lecturer at the Department of History at Columbia University, and also the author of Goliath, the 100th year war between monopoly power and democracy. And we have Claire Chung-Ying Xia, who's the associate director at Nira Economic Consulting. Claire provides expert analyses in antitrust issues as it relates to the intersection of IP. She has worked on matters involving monopolization claims and mergers in the big tech industry. All right, with that introduction, we're gonna jump right in. We're not gonna have formal presentations, but really get into this Q&A and discussions and hopefully leave some time at the end for audience questions. So let me go to FTC Meta within. That was referenced in the commissioner's talk. And we can even go a little bit further back to FTC Steris if you're really interested in these issues of potential and nascent competition. It's a really kind of, I wouldn't say new or anything in that nature, but it's certainly in the news today. And so I want to start with Bilal. I want to address this issue of these two terms, both in terms of the law and economics, however you want to address it. Whether the labels potential competition, nascent competition are largely interchangeable, or should we keep these separate, and if so, why, and what's sort of the underlying rationale for that? And just to add on top of that, did the court get the decision in FTC Meta correct?
Okay, thank you. I think I'd say, in terms of this question of whether there's a meaningful difference between the terms potential competition and nascent competition, I'd say I think there is a difference, but in one respect, I think it doesn't matter. And I'll respond to that first. Look, what are we trying to figure out when we evaluate an acquisition, right? Whether, to speak loosely, whether it will harm competition going forward, right? That's the ultimate question. And the framework for analyzing the competitive effects of a transaction should be similar. Now, in practice, there is a doctrine of law built around, theories of potential competition that's, I think, fairly robust, even if largely developed, in the 60s and 70s in the case law, and then by the agencies in their practice, right, of reviewing and challenging mergers. That is less true with respect to nascent competitors, and there are not a lot of cases that discuss or use that term nascent competitor differentiated from potential competitors. And what do I mean by that? I think of a potential competitor as a firm that's not in the relevant market, at the time you're asking the question of whether they are in the relevant market. Now, it's clear from both the case law and the guidelines, those firms that are identified as potential competitors may have some effect on competition in the market, even when they are not in the market. A nascent competitor, by my sort of definition or understanding, is both a small firm or a firm with a small presence in the relevant market where there is some belief, maybe some basis for the belief, that they will have a future competitive effect that's greater than their current effect. And that's sort of standard merger analysis without the verbiage of the potential competition doctrine, whether an actual potential competitor or perceived potential competitor, and whether, what's the likelihood of entry, right? So naming, sort of naming or categorizing competitors, I think matters because of there's a lot of law on potential competition and how you might evaluate the effects of an acquisition involving a potential competitor, and less unique law on how you think about a small but promising presence in a market may indicate future competitive strength. The other term I'd introduce too is future competitor or future competition. Right? Two merging firms may both be in a relevant market, but you're still asking whether one or both of those firms will be an effective or even an actual competitor in the future. Right? Firms leave markets all the time, and so it's, I think, useful to also distinguish that category. Right? Who will be in the market, going forward, and what's the strength of their presence. So because of those, so I think those differences matter in how you evaluate the strength of a case or the value of a case. I'll say quickly that I think the court did get the case right in FTC versus Meta. There are parts of the opinion I disagree with, but in general, it applied, it applied the doctrine of an actual potential competitor that's developed in the case law, which focused in part on the likelihood or probability of entry, right? That's a question all those cases face. And also focused on, what's the evidentiary burden, what's the level of evidence that a plaintiff needs to establish the identification of a potential competitor. Largely, I think followed the law, made choices where there were differences in the appellate standards that seem correct to me, and I think found for the parties on what I'd call evidentiary or factual grounds. Right, there was not sufficient evidence that Meta's entry into the relevant market was likely or reasonably probable. So I'll stop there.
Okay. Thank you, Bilal. Matt, I wanted to give you an opportunity to talk about FTC Meta and the case and whether you thought it was rightly decided, and if not, what parts were good or bad you think for the commission going forward?
Yeah, well, it's thanks for inviting me. It's a pleasure to be here in front of all of you. I'm sure I've insulted a few of you on Twitter. When Josh invited me, it was very kind of him to do that. He said that I have to be polite, can't call anyone vampires or anything like that. And I said, I agreed to that, but I also said I'm not sure I'd have that much to say. I thought that was a good joke. Did you guys all collude to not laugh at that?
I laughed.
Thank you. I bet Josh I could make a collusion joke. All right, thanks.
Josh,
all right. So I'm going to read you something from, my basic frame on this case is I'm glad the FTC did something, right? I'm glad the FTC challenged the first big tech merger. And I'm going to read you what a Googler named Praveen Shashadri wrote 2 weeks ago. It's not Meta, but it's a very similar type of dynamic. Google has 175,000 plus capable and well-compensated employees who get very little done quarter over quarter, year over year. Like mice, they are trapped in a maze of approvals, launch processes, legal reviews, performance reviews, exec reviews, documents, meetings, bug reports, triage, OKRs, H1 plans followed by H2 plans, all hands summits, and inevitable reorgs. This is, as he wrote, the, quote, natural consequences of having a money printing machine called ads that has kept growing relentlessly every year, hiding all other sins. And I hear this a lot, not just from people at Google, but from people in large companies like Procter & Gamble or Facebook, whatever. Like corporate America, large companies that focus on gaining and fortifying monopoly power don't do anything. And this is a crisis. We are in a crisis of monopoly power, and you can pretty much see it everywhere. Corporations have, at this point, large corporations have high and persistent profits, and there are about half as many public firms today as there were in 1996, despite population growth. So we have significant problems with concentration in our economy, and you just hear this from workers themselves and people who leave to start new companies or just are not, or were bought at part of companies that got bought. So the first thing is I'm just glad that they did something, that they challenged a big tech merger. I know that there are going to be more challenges. One of the foundational experiences that I had during the financial crisis was seeing no prosecutions against white-collar executives. Jesse Eisinger from ProPublica wrote a book about this, calling it the Chicken Shit Club, saying that essentially prosecutors were afraid to lose. They wanted to win all cases. So I don't think that winning cases is that important. I think it's nice to win, and I wish we had won that case or the FTC had won that case. But that's not particularly important. The agencies should be losing a lot more cases than they are. So there wasn't a single merger challenge in the formation of the Big Five in the 2000s and 2010s, not one. And what does that say about the Clayton Act? It says that Clayton Act has been subverted by prosecutorial discretion. If the Clayton Act didn't apply to a single merger by any of those firms, several of whom have at least 90% share of an important market, then the problem is under enforcement. So my critique of the FTC and Antitrust Division in general is that they haven't lost enough. Okay, so talk about the actual legal doctrine at hand in the case. So when the FTC filed the case, I remember a lot of claims saying this case is crazy, extreme. So the Wall Street Journal editorial page called it the actual potential competition doctrine discredited. And such theories were used to attack conglomerate mergers a half century ago before the, quote, illogic and bad economics were taken apart. Bill Kovacic talked about how the case was experimental and used a relatively novel theory of harm. And the judge ruled otherwise, said this is a reasonable theory. And I'm glad here today that, that Chair Lina Khan, Becca Kelly-Slaughter, Commissioner Bedoya brought an orthodox case based on settled law. And that, I think, bodes well for antitrust going forward. Now, the other, I think, point here about this particular case is that it was an attempt to address a technological inflection point. So Mark Zuckerberg's goal with this merger was to do something similar to what he was trying during the Facebook, Instagram, and Facebook WhatsApp purchases, which was to ensure that Facebook could maintain dominance when there was a shift to mobile from desktop. It was a technological inflection point, somewhat similar to Google Android, Google DoubleClick. And there are a lot of technological inflection points, and those are the moments when you can create a new competitive environment. I think we're seeing one right now with ChatGPT and large language learning models. So, I could see these theories being useful for mergers that take place when a dominant firm is trying to maintain, fortify its monopoly or extend its monopoly when a new when there's a new technological paradigm to dominate. And it's another tool that enforcers can and should use to ensure that as we do see more technological development, that the future doesn't belong to the monopolist. So, many cases, I think Adobe Figma comes to mind, Microsoft Activision comes to mind. There's a bunch of cases, not to say that these theories will always be useful for those cases, but technological inflection points are kind of the most important cases, and I'm glad to see that the FTC did bring one, even if they lost on the facts.
Thank you. Thank you, Matt. Jeff, I wanted to give you a chance. Any thoughts on the case, potential nascent competition doctrine, if this is operational, and if so, what are sort of some conditions you think are good or necessary to bring a case?
Sure. Thanks, John. Thanks for having me here. Always great to be back at George Mason. Actually, most importantly, it's great to be back only a block away from El Pollo Rico. So, I'll mention a couple of quick things about the Meta case. I think it's kind of weird that people like the Wall Street Journal want to make it into a novel case. I think we heard enough this morning to be pretty clear that it's not a very novel theory that's involved. It's in the merger guidelines. There's a huge number of cases that have involved the theory from the 70s, 80s, and all the way up till Visa Plaid. I don't know if that's the most recent, but that's pretty recent. Bilal has an article discussing these cases. It's 113 pages long. And it's not like he discusses each case for 12 pages. I mean, there's a lot here. So it's a little bit absurd to say that this is not an established theory. And of course, the economics of it, at the very least, going back to Baumol, are pretty straightforward. So I think the application of the case law in the case was pretty straightforward as well. I would take one issue with something Bilal said. I don't necessarily approve of all the choices he made. And in particular, I think it's interesting that he chose the very easiest standard of proof that any of the prior circuit courts had applied in such a case. I was interested to hear you say that you thought he made all the right choices. Maybe that's the right choice, but I sort of question that. I think he could have adopted a different standard. Is it operationalizable? Well, yes and no. As I said, yes, in the sense that the theory makes economic sense, but the elements are necessarily hard to establish. And this is where I want to talk at a little more length about the sort of limitations of the theory and what we need to do in order to get it right going forward. I think the crux is that removing a potential competitor is not the same thing as removing potential competition. Right, all else equal, in a traditional horizontal merger, you remove a direct competitor, which in a sufficiently concentrated market could be presumed, we can debate presumptions later, to reduce competition, but that's not the case with a potential competitor. A potential competitor obviously may not be a competitive constraint at all. It's a probabilistic sort of thing. But more important, removing a single source of potential competition doesn't necessarily reduce competition overall, or at least not more than marginally so. I mean, it could, of course, and again, that's why the theory isn't absurd, and this is a point that John himself first made, so I will attribute it to him. If Instagram is a potential competitor of Facebook, there's been a lot of discussion revisiting that merger, at the time of the merger, well then so was TikTok, YouTube, Snapchat, Pinterest, a host of other nascent competitors that Facebook was also considering acquiring as well. In a sense, the potential competition doctrine assumes a theory of harm that by its nature increases the scope of competitive threats in the market. That makes it a hard theory to win on, right? By virtue of applying this theory, you're basically saying at least one competitor, and usually it's pretty rare if only one competitor can get over all the relevant barriers to entry that might be in the market, but at least one competitor, and therefore probably more, are competing in this market. You kind of can't have it both ways. And if you want to look at potential competition, you have to admit that the market includes potential competitor, including potential competitors, is bigger than just the incumbent and the single entrant that may be involved in the given merger. I don't think that's very well sort of encapsulated in the way that the doctrine has developed. Certainly not as unless I missed it, I don't think that notion appears in the Meta decision. And I think that's a real lacuna here. I think that we're missing something really important. Now, the caveat to this, as I said, is it could be that one potential competitor is the full extent of potential competition because there are barriers to entry that only this one firm can get around, which is why I think a key factor in potential competition analysis should be should be assessing the existence of and strength of barriers to entry. In some ways, that should be the very crux of the analysis. Again, we know there's one firm competing, there are probably more. Unless there are barriers to entry, you have a tough, you have a sort of a tough row to hoe. So let's figure out if there are barriers to entry that would impede additional competitors from coming in. In Meta within, this is one place where I think the judge got it exactly wrong. He said about all the companies that had entered the market since the start of litigation, it was one of the things that I think it might have even been Dennis, I can't remember who pointed out. Although the introduction of new firms and this is the judge responding to the allegation that, hey, there's a lot of competition here, new firms have entered the market. Although the introduction of new firms and fluid condition of market entry and exit can indicate competitive behavior, the bottom line is that these new entrants have not significantly deconcentrated the market, nor do they suggest a trend towards such deconcentration. That's the wrong way to look at it. That's looking at potential competitors from the point of view of maybe nascent competitors, but a sort of traditional horizontal merger theory. How concentrated is the market? But you've just sort of admitted by nature of adopting this theory that we're not talking about the exact strength and relative market power of the current competitors in this market. We're talking about the potential competitors who can come in. It's weird for him in a case that's steeped in that issue to then say, oh, hey, the fact of new entry doesn't matter because, hey, they didn't really deconcentrate the market much, so we're not going to take account of them. In a sense, I guess, going to the point you raised earlier about potential versus nascent competition, you could say that all of those companies that entered the market between the start of litigation and the time the opinion came out moved from being potential competitors to nascent competitors. But again, I think one of the similarities, one of the things that will always persist as a factor that applies to both nascent and potential competitors is looking at market shares. Present market shares is simply not going to tell you the relevant competitive dynamics of the market. So even though in this case we're talking about companies that were in the market, it's simply insufficient to look at their market shares and say that tells you all you need to know about the competitiveness and ease of entry in that market. So I'm going to skip a few things because, as usual, I have about 20 hours of content, and I doubt you're going to give me that long. But I will. I'll make one other point about the response to something Matt said, which is, I think that it's not surprising that the way most people look at potential competition, and in particular the possibility of a merger between an incumbent and a potential competitor, that most of the consideration there involves, or a lot of it involves, thinking about innovation, thinking about future dynamics in the market, and almost always, as I see it, with a consideration that future innovation could come from the new entrants, and the only really way that this question of innovation comes into the calculus is, are we removing the prospect of innovation from the market by allowing this merger? What isn't really taken account of, and I can't remember if it was George or someone earlier who alluded to this point, is the extent to which the merger may be facilitating innovation by the incumbent, and actually in this case, even sort of in a special way that probably arises a lot in big tech potential competition cases. Forget about nascent competitors, you have a nascent market here. The market doesn't even really exist. And if you're concerned about future innovation in this market, you're not going to have any future innovation in this market if the market doesn't exist. The notion that Facebook could have been establishing itself as a consistent and sort of reliable force to build this market by engaging in this purchase is not at all crazy, and I think it sort of leads to this point that should be true in all merger analysis, but especially in potential competition cases, you can't just look at the effect of these mergers on the sort of loss of innovation or efficiencies or whatever else from the removal of the potential competitor. I think you also have to look, again, especially in a nascent market, at the effect of the merger on the incumbent, who may be actually essential for establishing the viability of the market and the prospect of future innovation at all.
Thank you, Jeff. Claire, I wanted to get the sort of a perspective from an economist. What I find challenging about these cases, let's say Facebook, Instagram, is the postmortem. What are we supposed to look for? What is the counterfactual that would point towards anti-competitive, pro-competitive, or neutral results? I think that's fairly easy for the manifestation of actual competition. But these types of cases, I don't think it's so clear. But I want to turn to you for your thoughts.
Thank you, John. And thank you for having me here. And I think finding a counterfactual for acquisitions in the big tech space of nascent competitors is definitely challenging. But there is an economic framework that could potentially help us solve that problem, or at least get closer. So just taking a step back, and typically economists do retrospective analysis of mergers by comparing, say, prices before and after the transaction. And the main issue that economists have to solve is whether the change in the price that we find is due to the acquisition or because of other market economic factors. And there is a way that economists deal with that, which is called kind of a difference in difference model. Just very intuitively, and this is a hypothetical example. I lived in New York for many years, not in the city, outside the city. And there is a small grocery chain called Mrs. Green's that I really liked. Let's say that hypothetically, Walmart bought Mrs. Green's in 2020. And right afterwards, I saw that the grocery price in New York went straight up. Should I blame the acquisition for the price increase? You probably say, Claire, not so fast. What about the supply shortage after the pandemic? So as an economist, I would say, okay, let's go find a counterfactual, find a control group. So I would look for a market where the transaction didn't take place, but are similar enough to New York and are subject to the same type of economic factors that we're concerned about here. And let's say I decide that DC is similar enough. Then I compare the grocery price in DC before and after the transaction to the change in the grocery price before and after in New York. And let's say that I did not find a difference in that difference. And I would infer that the increase in price I'm seeing in New York after the transaction is really due to economic factors other than the transaction. So that's the kind of the economic tool we would use. But in doing that, we're making the implicit assumption that the control group is the counterfactual. So meaning DC is the counterfactual to New York in my example. And I think in that, coming back to acquisition of nascent competitors, the question comes back down to, can we find a control group for this type of analysis? And I think it is a very fact-specific inquiry, and I would just leave it at that.
Thank you, Claire. Okay, let's turn to the UMC authority, unfair methods of competition. We got a little bit of our thunder stolen from us from the commissioner. How dare her? But no, Josh asked her, obviously, about limiting principles, and she mentioned that the limiting principle is what Congress gave the authority to the FTC to exercise. And so I wanted to give the panelists, Matt, let's start with you. In the 2022 statement that the FTC released, is this the right approach? And how should the FTC exercise this Section 5 authority under that new statement?
Yeah, thanks for the question. And I thought the commissioner's answer was, I essentially agreed with her. So, Congress has, well, I guess I'll start with a historian named Gerald Burke, who's a well-recognized historian of the Federal Trade Commission and how Louis Brandeis thought and why it was formed the way that it was. And So he talked about how Louis Brandeis's thinking around forming the FTC was about redirecting business administration, quote, this is a quote, from deceit and opportunism to engineering, invention, and incremental improvement. So that's what you saw in the chair's description of the Section 5 policy statement, where she talked about the difference between fair and unfair competition. It's the statutory mandate given to the commission and authority by Congress. And the idea was to ensure that predatory competition or competition based on poor accounting standards, that was a big problem in the teens and 20s around railroads and economies of scale, that wasn't the basis for American commerce. And that moral claim and competition policy law has always had a moral basis. That has been the bedrock of from the Sherman Act to the Clayton Act, the FTC Act, Routes and Patman, Seller-Kefauver, Hart-Scott-Rodino. And the Section 5 statement that the FTC put out returns to that basic principle, and without it, what you find, and I think what you find in our society right now, commerce is increasingly based on deceit, opportunism, exploitation, coercion. So I think the best way to understand what the FTC is going to do with this is to look at what they've already done with the new policy statement. And the first example is a policy statement that they released on insulin. And insulin is a great example of a society that has based its commerce on flouting the FTC's statutory authority. So it was invented in 1922. And insulin in the US costs 10 to 100 times what it does abroad. People can't get enough insulin, they die, they spend too much money. It's just immensely wasteful. Why is it so costly? I mean, the answer is very clear for anybody who's in the industry, and it's bribery. Pharmacy benefit managers give a 50 to 70% kickback to insulin producers to exclude rivals from their formularies. Pay me more and I'll give you shelf space. That's the basic deals. That's the basic deal. So the agent who's supposed to negotiate for lower prices is getting a kickback to hike prices instead. There's something really wrong with our economy when you can get insulin much cheaper in Egypt or wherever else than you can get it in the US. And inducing PBMs or other intermediaries to place higher cost drugs on formularies instead of less expensive alternatives in a manner that shifts cost to payers and patients may violate the prohibition against unfair methods of competition or unfair acts or practices under Section 5 of the FTC Act. That is in the policy statement right there, trying to attack that basic problem, that basic sense of unfairness. Why are we in a situation where coercion and predatory behavior is the incentive in business? So an important reason is we lost the basic concept of fairness as a guiding principle in law. Congress said unfair methods of competition. And then people started asking the question in the 70s, 80s, and 90s, but what is the limiting principle on fairness? That is not what the statute says. So today, it's not that there isn't competition in insulin markets, it's that competition is oriented around increasing prices to patients. And that is unfair. It's also pervasive in our economy, and it's exactly what Section 5 was set up to address originally. So the second example is non-compete agreements, which the FTC found were coercive, restricted, harmful to competitive conditions. So there's simply an imbalance of bargaining power upon negotiation of the agreement and when the employee seeks to leave a job. Now, there's thousands of comments on the FTC docket, which you can read, but I've talked to plenty of employees and firms trying to hire who have been dealing with these agreements. And there's a lot of sexual harassment, bullying, various other things that people have to deal with. And essentially, a non-compete is telling an employee, even states where you can't enforce it, or even when the agreement is maybe people think it might be unenforceable. If you don't have $50,000 or $100,000 to challenge this agreement, then you stay where you're working, or you don't work. Or sometimes even if you don't get a new job, they'll sue you anyway. That's really what it's about. That's what a non-compete agreement is usually for. I don't know how to talk about that as anything but deeply, deeply unfair. And that's what most of the people who've commented say as well. So, this is, Section 5 is not an unbounded statute. It's designed to be flexible and have open-ended authority to catch unfair behavior where the tactics are new and creative, and where there are gaps in statute. That was very explicit at the time it was passed, but there are no private rights of action, and only the FTC can bring cases. So it is necessarily limited by design. We're not talking about the ability to write legislation. We're talking about Section 5 rulemaking, which is inherently limited by institutional design. So there's a lot of innovations happening in our society. There are constantly innovations in business, and innovation can happen around making better medicine, making better products. It can also happen around tacit collusion, coordination, predatory behavior. And so that's what this Section 5 is designed to capture. And I think you can look at other sort of limiting principles if you want, or, Sperry v. Hutchinson talked about what is fairness. It's something that is offensive to public morals. And you can choose to essentially take that and say we're going to put it into a very math-heavy formula and pretend that we're not making the same kinds of judgments, and we're just, because it's math. But that's essentially really what we're talking about here. So I think returning to that basic idea that an unfair method of competition in an institutionally limited capacity to address it, to take on where there are gaps in statute or where there are clearly coercive or predatory activities that involve imbalances of bargaining power. It makes a lot of sense, and if you don't do it, you increasingly have what we see in our society today, which is less and less and less faith in our institutions. And there we go.
Thanks, Matt. Jeff, what are your thoughts on the statement, the scope of the FTC's authority?
Well, it will surprise everyone to know that I see it very differently than Matt does. Let's see. I want to refer to a couple of things that Matt raised and that refer back to what Commissioner Slaughter talked about this afternoon, but then I'll go into a little more depth. Number one, I think I heard Matt say that there's no limit to fairness in terms of finding a limiting principle. There isn't a limit to fairness, and I think that's how Commissioner Slaughter interpreted. Is that not what you said? Something like that. Well, the point was that what Commissioner Slaughter said, and what I think you were implying, was that it's not the FTC's job to limit the scope of the statute. The FTC should enforce to the full extent of the scope of the statute. I think, at least with respect to Commissioner Slaughter, I won't say this is true of you, Matt, she was misinterpreting the nature of the question. The nature of the question is not what are the limits on the definition of fairness under the statute that the FTC wants to enforce in a scope that's less than allowable under the statute. It's you have an ambiguous term and you have to have some way of operationalizing that. What are the limits to your method, your definition of how you're going to operationalize the term fairness? That doesn't mean you're limiting what fairness means. It means you're trying to find a way to provide some clarity and some certainty in how the FTC is actually going to enforce that statute. Number two, with respect to Sperry and Hutchinson, it's true that court did say that, what UMC means is, or what Section 5 means is basically, public policy, public morals. It has that kind of language. And then Congress passed a statute that said, hey, FTC, you cannot make rules under UDAP, but there's some ambiguity in the language, and it's possible that it applies even to UMC. But it's very clear, because this was the issue at the time, that following Sperry and Hutchinson, Congress very clearly said, you cannot make rules solely on the basis of public policy. Sorry, you gotta have something that's more concrete than just your own view of what policy should entail. So yeah, you're right about that case, but I don't think that's really sort of where we land following subsequent congressional action. I also don't think the absence of a private right of action constitutes a relevant limitation in the statute. The reality is that there are essentially no limitations on the purported authority to make UMC rules under 6G. Derek talked about this at some length this morning, but on the theory that not all of you were here or maybe not awake then, I'll repeat some of it. The authority that's being claimed by the commission to make UMC rules appears in 6G of the FTC Act. And I'm actually going to read it because some people may not have read it in a long time. I mean, it's worth hearing the language just to sort of get a picture of the full extent of the language that apparently authorizes the FTC to make essentially legislative rules over anything it wants that it considers fair. The commission shall also have the power, side thought, also have the power from time to time to classify corporations. Oh, and also to make rules and regulations for the purpose of carrying out the provisions of this subchapter. And that's it. No indication of what kind of judicial review there might be, no kinds of indication of process, none of the discussion you get in Section 5 of the Act. That's it. It's very clear, as Derek said this morning, and also, by the way, consistent, as Tom Merrill points out, with practice at the time, with the way progressive era executive authority was established by Congress, that kind of a statute that doesn't prescribe penalties and that doesn't prescribe any procedures is a statute that authorizes rules about internal processes, and that's it. It does not authorize substantive rules. Now, I mean, there is an argument that I think I've heard Matt make and others have made that, this is kind of absurd that we're parsing this statute so narrowly when, what's at stake is this great big policy issue, this great perceived authority that the FTC has, and this question shouldn't be turning on some, arcane question of exactly what words are used in the statute to establish it. Well, should or shouldn't, that is the way the court does it today. And it's not just the Republicans or the conservatives on the court, it is the entirety of the court. Look at the ruling in, oh my God, the name just, AMG. Unanimous ruling in AMG, which essentially reflects this. The way the court today, and lower courts as well, look at statutes like the FTC statute is different than the way the, HSR, the case.
National Refinery.
Not National Petroleum Refiners looked at this question in the 70s when it first found that the FTC did have this authority under 6G. Things have definitely sort of changed since then. It's hard to say that that's still good law. It's also, as I think Derek pointed out this morning, only good law in the DC circuit. And when this is challenged in another circuit, it's not going to be binding precedent. And I think we can all agree that following AMG and following West Virginia versus EPA and following other cases, that this Supreme Court is unlikely to suggest that National Petroleum Refiners is good law. So even if you disagree with my interpretation, I think as a practical matter, there's no way that this authority stands. But I think if you just look at the statute and the way it's written, it's very clear that Congress did not intend the FTC to have this authority.
Thank you, Jeff. Bilal, I want to give you an opportunity to weigh in.
Sure. So I'll be brief, I think. First, a lot of what Matt has suggested is at least potentially problematic. Strikes me best characterized, if it's characterized as something the FTC should do something about, as best characterized as an unfair act as opposed to an unfair method of competition. I think where the agency did pull back on its use of UMC in the late 70s, early 80s, when it became hard to establish that the conduct they were concerned about was not sort of competition on the merits, right? Many of the earlier cases that were sort of UMC / competition cases, were protecting less efficient competitors, or focused on very speculative harm in the future as an effective conduct that may be in the present simply hard competition. And that's why I think those of us who are concerned about where the agency's going ask about either definitional questions or limits on the authority, right? When we hear stuff about coercion or predation, you ask yourself, who is being protected by this? Is it a consumer? Is it competition as a process? Or is it merely a competitor who, is unable to react successfully against, new products, new ways of doing business, new arrangements between customers and suppliers? So, I think we all agree that the FTC's UMC authority is broader than reaches broader than the prohibitions of the Sherman Act. But what I think many of us are concerned about is that what the agency intends to do is protect firms from, hard competition, and use of terms such as coercion and predation without more make it hard to understand what conduct will be evaluated as competition on the merits and what won't. And that case law has developed in the context of Sherman Act cases over the last 40, 50 years in a way that the agency it just wants to push aside as related to application of the FTC Act, and it seems wrong and wrong-headed and potentially wasteful. Right? There are things they can be doing that aren't as expansive as they suggest their authority is.
Thank you, Bilal. So in an attempt to spice things up on a Friday afternoon, let's talk about algorithms, artificial intelligence, and antitrust. Of course, I revealed a lot about myself by calling this the spicy topic. I don't know if it is or not, but let's go to Claire. Claire, one of the things I'm fascinated by this literature, I don't know if a lot of people are, but is algorithmic collusion and the concern over that, and whether it's through AI, machine learning, or just simply sophisticated computers, allowing for collusion tacitly in a way that we haven't before. Are there sort of conditions that this new technology brings that raise the fear, perhaps lower it, or maybe we're dealing with the same issues that destabilize cartels and collusive agreements generally, and it's really no different in our new digital age? But I wanted to see if you had any thoughts on that.
Thank you, John. And absolutely, I really love this literature too. So there are various categorizations of scenarios in which algorithms can collude. So I think the scenario that John's talking about is one in which self-learning algorithms adopted by companies is eventually evolved to a collusive equilibrium without human invention. And so the literature on this so far has helped answer two questions in my mind. One is it even possible? Is it science fiction? And the second one is, economics teaches us that there are various conditions in which that would make collusion either easier or harder to achieve. Do those conditions still apply in the context of algorithms? And so before I dive into the literature, I just want to say most of those studies are done in what I would call like a laboratory setting. So they're simulations. And the authors all say they're more of a proof of concept, and they do not reflect the real world complexities. So with that, I'll go into the first question, which is it possible for learning algorithms to reach or sustain a collusive outcome? And studies have found that, yes, it is possible under certain conditions. I won't list each condition specifically, but I will offer some intuitions on why those conditions are in place. So for collusion to be achievable and sustainable, we essentially need kind of three things. One is, under a collusive outcome, companies are essentially making the pie bigger. But then they have to be able to agree on a way to slice the pie that all of them feel that they're better off. Otherwise, the incentives to cheat is very large. So one way to make it easy to slice the pie is to impose a condition that all the companies are symmetric. And then on the flip side, we also need to sustain collusive outcomes, or not we, but companies who are or algorithms who are trying to collude. So there's a need to monitoring what's going on and to detect cheating and also punishment. So to make monitoring detection easy, oftentimes the condition of perfect information is imposed, and also the assumption that the market is very stable, like all the demand conditions are known, they don't change over time. So under those set of very strict conditions, researchers have found that self-learning algorithms can reach and sustain collusive outcomes. So to the second question, what if we relax those conditions? And there is emerging literature on this. I won't go through each factor because I think I'm just going to bore you. I'll talk about two of those strands. One is, what if we introduce noises to the market? In other words, we make it harder to monitor and detect cheating. And one way to do it, kind of from a theoretical point of view, is to make demand not so stable. So we allow demand to change over time. And we also make it not so knowable to all the sellers in the marketplace. And with that, monitoring becomes imperfect. So the question is it still possible for self-learning algorithms to achieve a collusive outcome? And research in this area found it is still possible, but the likelihood goes down. The second element I would talk about is researchers have found that consumers do matter. Because on the consumer side, we're seeing a lot of price aggregators. So consumers can go search for different prices offered by different sellers. And on that front, literature has found that if we have some sort of pricing aggregator for consumers, that the cheaper product is displayed more prominently or longer, it actually lowers the likelihood of collusion. And in fact, pricing algorithms in those circumstances have a stronger incentive to compete. So just those two factors can change the likelihood of collusion in those simulated settings. And I would say that there are a few factors in economics literature that can affect the likelihood of collusion, but just to my knowledge has not been tested or simulated. And I would just mention one, which is entry. So all of the literature that I have encountered so far assume a fixed number of players in the market. And but once we achieve a situation where all the players are colluding for an extended period of time, it seems that there may be room for, or incentives for, the potential entrant to come in. And how would that do to the equilibrium? And will collusion be sustainable then? So that is another question. Just to summarize, I think in a simulated environment, researchers have found that it is possible for algorithms to collude, but those simulated environments do not yet reflect the complexities in the real world. So there's a lot to be done there.
Thank you, Claire. Matt, everyone's talking or seemingly talking about OpenAI's ChatGPT, or maybe even sort of for Bing's GPT. It's gone rogue. I find it fascinating. I find it hilarious. But there are concerns about this technology, where it's going. Perhaps there are some interesting implications on its impact on incumbent platforms. What's your view of this technology? What are some pitfalls and sort of opportunities?
Yeah, thanks for the question. So just to follow up on something that Claire said, I mean, I want to talk about Section 5 and new areas of activity when algorithms are just engaged in some forms of tacit collusion, or how do you address something like that? That's kind of that's where could be gaps in the law, and sort of where Section 5 could come in handy as our economy gets restructured. And I do think that is what's going to happen. But so, yeah, just to talk about a couple of things that. So I'm going to start with a quote. This is from Leon Kieserling, who was the head of the CEA under Truman. So this is in the late 40s, he wrote, "The realm of science and its application to technology is expanding at a startling pace. Its limits are beyond calculation. The advances of the future can be made to serve the common welfare by affording opportunities for initiative and enterprise, or they can contribute increasingly to the growth of private monopoly." There were a whole series of cases. It forced the non-discriminatory divestment of patents. That allowed for lots more innovation, breakup of AT&T in the 80s too. There's ensuring that, as Alfred Chandler, the great business historian, said that this would be the electronic century, and said that the reason we developed these remarkable industries, color television, computing, semiconductors, was in many ways because of what he called the gods of creation, which were antitrust enforcers. I was so excited that by Alfred Chandler's commentary that this came off. So I think that's really where we are with large language learning models and these data sets, these tools that build algorithms based on large sets of data. I don't like the term AI, but that's what everybody calls it. The technology offers the ability to generate language in real time that can do everything from summarize technical documents to write legal briefs, to offer search results, friendly chat, and it's not new. The underlying technology was actually created in the late 1950s. And large data sets to train algorithms have been in commercial use for a little less than a decade. Amazon actually in the mid-2010s started to implement these types of models in in how they dealt with vendors. So now vendors, when they're negotiating with Amazon, are negotiating with an algorithm. The recently launched LLMs have problems. They lie, they hallucinate, they say crazy things. I'm partial to all that, but generally people don't like it when they're lied to about, or people say crazy things. But the technology is getting better. It's indistinguishable from magic, which is how you know that it's pretty remarkable. And it's possible that LLMs can be used for customer service, finance, coding, emails, kind of the co-pilot for everything. And these AI-style tools, which are not LLMs always, but they are impacting everything from protein folding to calculations around nuclear fusion, automated legal document drafting. Bain Consulting has an alliance with OpenAI to help companies figure out how to use image generative AI. Now, the most significant barrier to entry is cost, computing hardware expertise. It's extremely expensive to train an algorithm on deep learning. It can cost up to $100 million to train, have huge amounts of data. In 2020, Microsoft designed one of the top 5 supercomputers in the world for OpenAI, and it has 285,000 CPU cores and 10,000 GPUs. And there are a limited number of experts right now. But what is exciting about this moment, because I think that we are sort of in the beginning of seeing augmented, these kind of augment our intelligence. They're tools that do that. Is that unlike what we've been seeing for the last 40 years, this is happening in a moment where people are paying attention to concentration and monopoly, right? So I read a report, it's in my notes that I can't find, National Artificial Intelligence Resource Task Force. It's a really long name, and there was some acronym they used. But anyway, in that report where they're talking about these technologies, they talked about concentration. And it's very much back to that, what Kieserling was thinking. And the Antitrust Division, the Federal Trade Commission are hiring technologists, national security apparatus is structuring sanctions to retain US leadership in AI. I get a lot of feedback from AI engineers who are thinking about competition policy, monopoly policy. This is happening in a different moment than we saw, say, Web 2.0 develop after the Microsoft case. That was really the last time there was thinking about what to do in terms of competition in that space. It was more, enforcers decided for a variety of reasons that that market actors knew best, and I think that's not the case today. So I'm pretty excited. I mean, when I talked earlier about one of those technological inflection points, this seems to be a significant one, and I think that there is a lot of thinking going on into how to ensure that these tools and techniques are not monopolized, and no one wants to see another Microsoft Windows or Google search. And that's what I would be thinking about if I were, as you guys continue your research and your work. And I mean, I guess I'll just say, to link it back to some of the other things that we've talked about, I mentioned insulin, which is having huge problems, but how Google itself is essentially not, people there are not really doing very much work. I could talk about medical shortages, and SHAR started happening in 2012, and you guys are going to need medicine at some point. We're in a real crisis, and in this room, what I'm hearing is a lot of procedural talk, but I'm not actually hearing anyone coming out and saying, I've dealt with people who have non-competes and can't go and develop something new, or a doctor who can't actually treat different patients because that they're locked into a non-compete. I haven't heard any solutions to real policy problems, and the laws were written to address those policy problems. But what I've heard is that our particular version of the law is the way we want to enforce the law. So national petroleum refineries, yeah, it's precedent, but that's not really, right? Just why? Because not really. Robinson-Patman Act, that hasn't come up today. It hasn't been enforced. Enforcers chose not to enforce that. Why? Because they decided they didn't like it. Consumer welfare is nowhere in the statute. They just put it in there, right? Sperry v. Hutchinson still does apply to UMC authority. They retracted it narrowly just for UDAP authority, but it's in a lot of other statutes, and it's still in the FTC statute, and just decided, well, maybe this statute that doesn't apply to UMC should apply to UMC. Is that the way that people think? Is that the way, Jeff, that you think about law? And then the merger guidelines, the 1982 merger guidelines that people think are remarkable. I mean, that they were very deliberate. I mean, this is coming out from the Reagan archives. The reason that Baxter put those guidelines out the way that he did is there were internal discussions at the Reagan White House that they could not convince Congress to change merger law. They were thinking of doing it that way, but they said we can't. So one thing we can do is we can just rewrite merger guidelines. So when I sit here and hear a lot of questions about whether the FTC or the Antitrust Division are coloring within the lines of the law, or all of this concern for congressional intent, I sort of, and then I pair that with the total lack of concern for real policy problems that these laws were written to address. I just sort of see this exercise as as just rawly trying to do politics through courts, through judges that we're hoping will stop the laws that Congress wrote. And more broadly, I think we are in a crisis where we are devaluing work and valuing the acquisition of monopoly power. And it's very similar to what you see on the left when you think people just want to redistribute the bounty, assuming there's always the bounty, but someone's got to do the work. That's what these laws were written to protect. And increasingly, people aren't doing the work. So one thing I am excited about is when you see these new forms of, these new tools, and the people creating them and the people in policymaking positions are thinking, how do we make sure that these tools are accessible broadly and are not monopolized as they transform our economy? But I really do think there needs to be a different way in this room of thinking about the law, where you pay attention to congressional statute and don't just discard precedents you don't like and discard laws you don't like, but actually work through Congress and act faithfully to the law and to the policy problems that they were designed to address. So that's my answer to ChatGPT and sort of the broader conversation.
Thank you, Matt.
It sounded like a ChatGPT answer.
The topic of Google reminds me of some headlines I shared with my students the other night. 6 to 8 years ago, the headlines on Google is that they are the new Standard Oil. Monopoly is unsaleable. It's done. Barriers to entry are too high. And what's interesting is And then I shared the headlines from the past 2 weeks. And apparently it's all over for Google. And the former creator of Gmail said they're done. And I'm not sure I believe any of these headlines either what direction. But Jeff, what are sort of your thoughts on this technology and its potential to disrupt any of these types of markets that we're worried about?
May I just quickly respond to Matt?
Yeah, you can do what you want. I'm not going to stop.
I would just say, Matt, that the argument I was trying to make was a descriptive one, not a normative one. And I do, before you say anything, normatively, I do think that, for example, the non-compete rule is terrible, and I will be happy when it's struck down by the courts. But my argument wasn't that we should be doing this. I was trying to suggest how I think the courts will actually review it. And they may be wrong to do so, the way, like sort of ignoring national petroleum refiners in a different circuit. Like maybe they should. It's the only case that's really opined on this. And even though you're in the Seventh Circuit, maybe it should be controlling authority there, et cetera. My point was to say it's not controlling authority, whether it should be or not. So I'm just predicting what I think is going to happen. And I think it's pretty clear that the laws are going to be struck down. I do think, as a normative matter, they should be, because I think the accession of massive amounts of discretion without any real oversight by the FTC is really dangerous and problematic, and not just because I disagree with that particular outcome, but even if they were to adopt some rule or some enforcement action that in theory I agreed with, I would still, I hope, object to the exercise and the aggrandizement of the FTC's power. So on ChatGPT, I think the answer is it looks like a disruptive technology, and as with all disruptive technologies, we don't really have any idea what's going to happen. I may be wrong about this, but I don't really think that anyone sort of predicted that large language models were going to be the end of Google, right? I mean, I understand that they're saying that now, that it's emerged because of ChatGPT as a kind of alternative to Google, whether they're actually right about those predictions or not. The real point is, I don't think, but I could be wrong about this, that anyone was saying that, oh, hey, once we get these LLMs fully established, we're going to unseat Google. Like, no one was saying that 10 years ago, 5 years ago, even 1 year ago. But, someone could correct me if I'm wrong about that. The point is, it's always unpredictable. That has a lot of implications that are well understood. But here, I think it's fair to say we certainly shouldn't jump into the notion that any concerns we might have with the power and the way it's being exercised by Google or other companies is no longer of any concern to us at all because ChatGPT exists. Like, that doesn't make any sense because, again, we don't really know what's going on. If you have concerns about Google, if you had concerns about Google last year, you should still have them today. A little bit of Bayesian updating is in order, but I wouldn't abandon the entire approach just yet. Where I do certainly disagree with Matt, and I think is a big concern, is how we're going to regulate these things, right? And the EU is as seems to be the norm these days, out ahead of the US on this. There's been sort of versions of artificial intelligence regulation bandied about in the US, and I'll say two things that I think are really concerning about the way that's unfolding. The first one is to say I will agree with Matt that the relevant trade-off is pretty clear. It's not that AI can't be problematic on a host of different dimensions, including potentially its ability to facilitate and exacerbate concentrations of power. The trade-off, of course, is that it can also be immensely valuable for society in also a sort of unending host of ways, and we obviously shouldn't overly constrain those out of fear that we're going to be heading down a path leading to increased concentration or other harms. But we should take seriously that trade-off. I just think we seem to be, and Europe certainly seems to be, jumping a little bit too rapidly into the let's regulate this thing before we even understand it. And as I said, in two particular ways I would mention. Number one, the scope of the language in the European and the Artificial Intelligence Act is so broad as to basically encompass all software. Even a macro in an Excel spreadsheet could be actually come under the terms that are sort of currently, it obviously is in flux, but sort of currently as it stands in the European Act. That can't be intentional. At least I don't think it's intentional. It certainly isn't in the spirit of what the Act is supposed to be concerned with. Obviously, we really have very little to fear from the operation of Excel macros. Well, some of us would say we have a lot to fear from them, but you know. And yet that does risk constraining significantly the kind of benefits we can get from this stuff. And I think it's a mistake to fall on that side of the line. It also, by the way, doesn't do much to cabin the things that are really harmful in artificial intelligence. So it's sort of all the bad and not much of the good. The other thing that I think is happening in the regulation of artificial intelligence space, excuse me, is the sort of concerns, and this actually kind of relates to the collusion point. There's definitely a sense in a lot of the way this is interpreted that there are things that can be done with numbers or algorithms or computers that sort of by nature, by virtue of the fact that they're being done by algorithms or numbers or computers are problematic, even though we wouldn't necessarily say they're as problematic or problematic at all if done by humans. Again, the European regulation doesn't do a great job of sort of, it's sort of overly formalistic. It doesn't do a great job of focusing on effects. It does a very good job of saying, here are if you do X with a computer, bad. Even if we say if you did X without a computer, it might be okay. I would just like to praise the FTC in this regard. The sort of one, I don't know, what was it, about a year and a half ago or so, the FTC put out a sort of a blog post, really. I mean, so not quite the same as an actual regulation, sort of discussing, sort of potential concerns around artificial intelligence. And it was really remarkable how much that statement reflected a concern about potentially harmful effects, a lack of totally formalism. In fact, there's a statement in there, I actually quoted it, but it'll take me too long to find it, about how, we don't really care if you're doing these bad things with computers or without them. If you're doing bad things, then, we don't want you to do them and we'll enforce against you. It's a really, it's a sort of a really refreshing kind of statement. Again, it's like a year and a half old, so I don't know if it still holds sway, but certainly suggests that at least a year and a half ago, the FTC was looking at the regulation of artificial intelligence in a much healthier way than at least the European Union is. And I hope that will continue.
Thank you, Jeff. We're obviously winding down here. We're in the home stretch. I have a few final questions for Bilal and Claire, but before we get there, I wanted to see if there's any audience questions. Oh, there are. So I see Alex back there. Alex, watch. And then, did you have your hand up, Alex?
Yes.
Oh, go ahead.
Sure. This is mostly for Matt, but it'd be interesting if others weigh in as well. You define fairness as, in terms of the public morals. And, in a country as divided as ours, perhaps in any country, there's not a lot of agreement on, on public morals. I mean, just trying to think of an example. But, for example, some people would say that innovation is most important. Others would say, no, equity is most important. So I understand your point about the statute not defining fairness well, but how do you leave such a broad definition in place and not have it just be a license for regulators to impose their own policy preferences or view of public morals on everyone else?
Well, I mean, it's not just saying unfairness is banned, right? It's unfair methods of competition, and so it has to be a method of competition, and so that is very limiting. The essential idea is forms of cheating. I think there's consensus around what that looks like in business. I mean, there's a lot of I think. There's a lot of disagreement over certain important issues, but broadly speaking, I think there's still consensus in the U.S. about what is fair and unfair business behavior. So I don't really think that you're giving regulators huge grants of authority. If you look at the statement, it is essentially saying that, or the policy statement is essentially saying that it can kind of reach a little bit further than the antitrust laws, may not have as much of a need for a market definition, or can, you can look at the statement on insulin and the non-compete statement, and what you'd find is those are both looking at actions that are coercive, abusive of bargaining leverage, and affect broader market structures, but wouldn't necessarily be cabined into the same area as you'd see with the Sherman Act or the Clayton Act. So I don't think that there's I don't think that there's it's sort of that broad, and I think there's pretty much consensus that competition via means of deceit or coercion or other acts that I think everybody would call unfair, there's consensus there. And I also think that there's probably more consensus there than there is on what consumer welfare means. I know there's a lot of sort of arguments, we have a standard, and but I'm totally confused. That debate over what consumer welfare is or total welfare, it's totally confused, and arguments among economists about how to measure are quite arbitrary. So I don't think that, ultimately what law comes down to in many cases, and we see this with prudential standards, is just sort of, what does a reasonable person think? And you can say, we have a limiting principle because we throw a lot of math at it, and we have a bunch of oracles who sort of argue with one another and have some sort of consensus about what is and isn't reasonable. But all you're doing is taking that you're not limiting the principle, you're just saying, we're going to have a different group of people that aren't the citizenry decide what is and isn't reasonable. So I think there's pretty much consensus here. I think Congress wrote it the way that they did for a reason. If there wasn't a limiting principle to unfairness, they would have written it differently.
Probably have time for one more question. Is there another question? Oh, right there.
Hi, Cecile Coors with TIG. Matt, I've worked in the antitrust field since I graduated from this law school 20 years ago. And I found your statement that the government just decided not to bring any Robinson-Patman Act cases because they just don't like it to be a little bit empty. Perhaps because you're not aware of why they don't like it, and it's actually harmful to consumers at the low end of the economic scale. Why do you think the Robinson-Patman Act needs to be enforced? Just because it's out there doesn't mean it's a good law.
Maybe it isn't a good law, but take it up with Congress. My point wasn't to argue that Robinson-Patman is a good law. I think it is. But my point was to say, let's not act like there's a tremendous faith in the statutory guidance from Congress. There isn't. And the choice to not enforce Robinson-Patman, because as you said, it's a bad law that you think is harmful to certain classes of people. I mean, you don't want to enforce a law, that's fine, but don't go into law enforcement.
I just want to react to that a little bit, since I'm teaching the Robinson-Patman Act now. I think it's wrong to say the agencies decided not to enforce the law as sort of some kind of preference that they didn't like the law. I think what the agency saw was that the prong of the statute that sort of requires a showing of harm to competition, injury to competition, harm to competition, was going to be very difficult to meet, as their understanding of competition grew. And I think that's why the agencies moved away from it, right? Not because they didn't like it. Of course, there continued to be private enforcement of the law. And it's, I think, unclear, or maybe very clear, that there hasn't been real harm to competition here from the agency's, limited or lack of enforcement. So, I think they are being very faithful to the statute because of the difficulty of showing harm to competition, which is in the statute.
So we have probably time for one, in the interest of a populist approach, I'm going to go to the audience for the last question instead of my script here. I hope the panelists don't mind. So there's time for one more question. I guess, Alex, go ahead.
Yeah, quick. Is this working? Quick question for Claire, following up on Jeff's point about whether or not you're doing something manually or using AI. It kind of, the way you get there shouldn't matter. I've read a bunch of economics papers on algorithmic collusion. You've probably read more than I have, but the ones I've read, the machine learning is extremely simple. Extremely simple. It's something that a dim-witted brand manager could do, just sort of following dynamically, what are my unit sales, what's my price, what are my rivals' prices. There's nothing about it that suggests that there's an increment to the AI component. And when you say that, as the economic environment gets more complicated, algorithmic collusion gets more complicated, well, so does human collusion. And I want to ask you, is there any clue in the literature that suggests that there's an increment that the AI part imparts, holding fixed the complexity of the market that humans couldn't do on their own?
So that's a really interesting question because it is a question that the literature has wondered. I absolutely agree that most of those simulations adopt very simple algorithms that one could argue that humans can easily take up. And there is a few papers I'm aware of that they were looking at like the type of algorithm that's being used in those simulations and how that affects whether a collusive equilibrium could be achieved. And the findings there was pretty shocking, which was the more complicated the algorithms get, the harder it is to achieve a collusive equilibrium. So I don't know if that completely answers your question, but that's like interesting finding in the literature so far.
So I want to thank the audience, and please join me in thanking the panelists.